and abide by professional courtroom decorum. That means no driving, no drinking, no eating, no smoking, no lying in bed, no picking up the kids, making them breakfast, dropping them off. Can't be at the dentist's office, can't be at the doctor's office. So again, find some place where you're comfortable, be seated and be still.
We had a trial in the matter regarding the custody of one child, which the court concluded. In concluding the matter, the court recognized that there were some questions unanswered with regard to the amount of child support. So for the purposes of the issue of the child support matter, the court opened up this hearing so that we can take care of that matter. All right, so with that being said, let me allow parties to call their first witness. Ms. Brewer, I'll start with you. Sure.
Judge, I have a slight problem because I did not receive, Ms. Feldergate sent me her documents by 4:45 yesterday. I didn't see them until about an hour ago, so I have not had a chance to review them in terms of dealing with I see what's there, but I haven't had a chance of looking at the individual documents. So I would need a few moments to do that if possible.
You mean you want to reschedule this hearing till later today?
We could do it later today. I wouldn't have a problem with that.
I mean, I have I can squeeze you back in. I have because I start my 9 o'clock, which is a civil contempt calendar. Mm-hmm. So whenever I can just pull you back through that calendar.
All right, that would work. I just need, and I think it's not that many exhibits. I just need to be able to go through them individually.
All right, so I'm gonna start the other calendar and I'll call you probably about 30 minutes or so.
All right, thank you.
These are official court proceedings, which means you must adhere to and abide by professional courtroom decorum. That means no smoking, no driving, no drinking, no eating, no lying in bed, can't be at the dentist's office, can't be at the doctor's office, walking through the park or walking through your place of employment. Find a place where you're comfortable, be seated and be still. Please be mindful of your background noise and your background environment. The court states if you fail to abide by professional courtroom decorum, you may be removed from this Zoom.
Good morning, Your Honor. Chris Brown for Ms. Horn. This is the court will recall a continuation of a prior proceeding that started in February, and we had some supplemental matters. We had the trial in February, which the court has not issued an order yet, and then a status conference in May, and now we've got a supplemental contempt hearing for today. So, excuse me?
What did you say the court did not do?
The court heard the matter in February. On February 9th, we had a trial, and you did not issue a written order following that trial.
Yes, I did. Yes, you did.
Okay.
Your Honor, that's Jenny Winkleman. The order, if I'm understanding correctly, included the order of incarceration.
Yeah, that's.
Oh, okay. Okay. Well, yes, and I beg your pardon. I didn't. So if that was the court's order from the trial, then so be it. There were no findings other than the order for incarceration. So I misspoke. So you issued the order for incarceration following that May 24th status hearing.
Let me pull up everything. Let me just see exactly what it is. But I didn't think I had anything outstanding in this case. In fact, I was kind of celebrating the other day because I was like, yeah, I got everything done. So let me see. Yes, I celebrated too early. Let me see.
We filed a supplemental motion in April, and then a motion for contempt, and then a motion for contempt of the order for incarceration that the court issued in June. And so those two matters I understood would be heard.
Give me 1 second, Ms. Brown. I'm going to ask you to repeat that. I'm pulling up the file now so I can follow you, okay?
Sure.
Someone was detected at the right fence.
All right. So what was that hearing date again?
February 9th.
It was February 9th. Okay, let's see. Yeah, it looks like I talked about the paragraph 1. I indicated that defendant must provide written proof of all liens covered on the house. And if the liens are valid, must give plaintiff access to the second mortgage lien holder and other accounts that are due. in addition to paying the $20,000. And then upon payment, I think $3,000 was to go to Miss Horn. And then I get the incarceration order for failure. Any others not addressed will be reserved for another hearing on this matter. The parties will receive form. Any other issues not addressed herein will be reserved for another hearing on this matter. And so that I signed that in May. Okay, so let me see. Then you filed a motion for contempt on the 25th. Okay, so tell me, from that February hearing and the May order that I did, indicating that he's to provide those things to you, what is the outstanding issue you believe I had not yet addressed?
Well, there were several things. So there was a medical bill presented. There were monies that were owed to my client that were alleged in the original petition that was filed in October.
The original petition, okay.
And so I did not understand you to rule on all of the issues in that petition. And I'll need to go through, because I knew today was just the supplemental. I don't have that in front of me, but I'll go grab it.
Yeah.
But there were specific monies owed to her. And then, so I didn't interpret that to be a full and final order. I interpreted that to be, when you had.
No, it was not necessarily full and final. It recognized that there might be some outstanding issues. That's why at the end of it, I indicated if there are any other outstanding issues, we will address them later. And I may have been trying to take care of what was the hot bed item at the time, but I'm looking now to kind of see. But I remember going through the medical stuff, and I don't know what. Let me see. Let me go back to response emotions. Okay, maybe it was in a related case. The one maybe I was thinking the case where the court had made the decisions with regard to clarifying the contract. Clarifying the terms of the agreement. Maybe that's what's in my head, and maybe that's why I was thinking, because I'm reading here, and the only order based on the contempt that you filed in October of 2022 is that May order. And you're right. That's all I see. All right. I'm sorry. Go ahead. You may proceed.
That's all right. What the court is remembering is there was a prior contempt, and you did issue a final order in that in May of 2022. Right. And that order did clarify the timing of when certain things would become due, specifically at issue here, the lien payoffs and the second mortgage payoff. And in that order, you said everything had to be paid off by January 1, I think, of 2023, which is the interpretation. And so you made a final order on that. We are back because he didn't pay pursuant to your final order on attorney's fees and other things. And then by the time we came to court, it was ripe to discuss the fact that he didn't pay off those liens on January 1 in the second mortgage, because those things were pending. So those are all things that the court hasn't ruled on in terms of him being in contempt. You did have that status conference and had him pay a sum into registry, and then you issued a subsequent order where you allowed me to make certain payments on some of the liens out of those registry funds, and I'm prepared to address that today. But in the meantime, my understanding is you've not issued a final order from the February trial. We had a supplemental motion that we filed on contempt issues in April for ongoing things, and then we contend by our June filing that Mr. Horn did not comply with your May order for incarceration. And then as well with that, we have an outstanding claim for attorney's fees that the court has not heard. So those are the things that I understood would be addressed today. The good news is, in response to your request for a time announcement, Ms. Winkleman and I discussed all of the status of things by phone yesterday. And I think we're prepared to mostly proffer, because I think we're aligned on many of the facts and the amounts owed. I think we're just a little bit hung up on whether or not he should have paid those things off and ability to pay. And I think she and I discussed is just sort of have a proffer and pretrial with the court, if you will, although all on the record. And so I think my announcement, if we can do it that way, I'm going to say 2 hours to be safe, because last time we went over, and I know that it doesn't please any judge when you go over a time announcement, but so 2 hours.
All right, so 2 hours. And that is including just your side, or you think it's a total for you and Ms. Winkleman?
I think total, if we can do it by proffering and sort of a discussion on the record, and just query the clients as needed. I'd ask Ms. Winkleman if she thinks I'm incorrect on that.
Okay, great. All right, so let's do that. I'll put you down for 2 hours. Is Mr. Horn present?
He is. I think he couldn't get audio, and I'm not sure his camera's working. So if it's okay, I'm going to have him restart one more time. But
Yeah, he could be on the other screen. I just don't see him open.
I am here, Your Honor. Audio is working, but I can't seem to get video to work.
Okay, yeah, you probably go back out and come back in so we can get video on.
All right,
Okay,
let me try that. I'll be right back.
Okay, I'm gonna put you down for 2 hours. Thank you.
Thank you.
All right.
Also have the guardian ad litem in this case. Dr. Marsha Brown is here today.
Good morning, Your Honor.
It's my understanding, I guess we're here for Ms. Groves' contempt that was filed many months ago. So I wasn't even sure if that is actually still an issue, but I believe that's why we're here. So I don't know the time announcement because I'm not really sure exactly what the ongoing issue is. But I do know in speaking with Dr. Brown that the parties have not moved forward with her investigation, particularly Ms. Groves. My client has tried, but the case is kind of stalled at this point.
Okay, so I can understand. My understanding was that this was a motion for contempt filed by mother. So Ms. Groves, I'm sorry.
I just say yes, ma'am.
All
Your
right.
Honor, if I may,
Yes.
may I give you a quick call, please?
Yes. Give me a moment. So it looks like we have it noticed 2 ways. So it's noticed on the motion for contempt and guardian ad litem's written request. So before we entertain that, let me start with the guardian ad litem to kind of see what the issue is so that I'll know whether it has any bearing on the motion for contempt.
Good morning, Your Honor.
Good morning.
The parties have paid their retainer fee. It was a little bit delay on that. I sent out letters June 15th for them to complete a documentation and schedule a interview. I've been able to be in contact with Mr. Allen, but Mrs. Grove has stated that the parties have decided that they did not want to move forward and would not cooperate.
Not want to move forward, what?
She just said they're not moving forward with this case and she would not cooperate. I can't get any documents from her. She's not willing to allow me to continue my investigation. My understanding, there's defects been involved in the case. I'm trying to get started or just having a little bit of issue with Mrs. Grove. Mr. Allen has done all the things I've asked him to do as of today. So just need a little bit of guidance of where I'm headed because Mrs. Grove seems to think that they have worked this out and they no longer need a guardian.
Okay, so is that your understanding, Ms. Groves, that the case is
During
resolved?
that time when the guardian was asking for that questionnaire, I was actually just going through a hard time in the middle of studying for the bar exam. So it was a real stressful time in my life. However, I was also privy in talking to the plaintiff, and me and him had prior discussions, went out to dinner, and he kept assuring me that he would talk to his attorney and drop the case. So I expressed that to the guardian as well.
Drop the case as in drop the legitimation? What is he dropping?
Whatever he was attempting to do.
Which is what, from your understanding?
To my understanding, it was a legitimation, but then it went on to a custody battle.
Okay, so the
Yes.
legitimation was not at issue. What was at issue was the custody battle.
Yes, ma'am.
Be primary.
Yes, ma'am.
Okay.
Right now, we have a temporary order where we're just doing shared custody 1 week and 1 week. That was set during mediation.
Okay. And then so when you told her that, what month were you in when you said that you thought it was resolved?
This was in the month August, I believe, maybe like
Okay,
August, September. I'm wrong. She's shaking her head no, so maybe it's not.
When was that? When was it, Dr. Brown?
It was in September, Your Honor.
Okay, September.
Okay, so that's fairly recent, but you've recognized now that y'all are not resolved and that your participation with Dr. Brown is necessary.
Yes, ma'am. I have the documentation here. I filled it out. I can get it over to her, but me and the plaintiff have been talking, and he's said that I guess there's just some confusion on me and his part of where the case stands. So, but if I need to turn the paperwork, and if Mr. Allen wants to move forward with this, if my understanding was incorrect on what we're doing, I will send it the documentation.
Well, let me tell you this, Ms. Grove, because we can't keep wasting time between your with Mr. Allen and what his decisiveness is. I don't care about that. I want you to turn in and you proceed like this case is going until I tell you otherwise.
Okay.
So if I say put up a document, put the document up. I don't care if Mr. Allen's position is we're going to make this resolved. Okay. Unless I sign this order saying this case is done, it's not done. And we're not going to waste 4 months, June, July, August, September. We wasted 4 months of you going back and forth, which is fine if you're still working with the mediator. If you're still trying to work it out, but you're working with the mediator, you're not throwing my docket down by 5 and 6 months because you all don't know what you want to do. So what I'm saying to you is now you're to work with Dr. Brown, even if you and your, even if you and Mr. Allen come to a resolution, that's great. Love to hear it. But I don't need to be stifled by the indecisiveness potential. Okay. So Ms. Stokes, have you spoken with your client? And do you have any information related to the fact that this is about to be settled?
Unfortunately, Your Honor, I cannot contribute to that. To my understanding, we're moving forward. So I do need to touch base with my client further, but we're moving forward with the case.
Okay. All right, then. And so let me just ask directly, Mr. Allen. Mr. Allen, is that the case? This is not in resolution, correct? You don't have any video.
Oh,
Okay, there you go.
all right. So Your Honor, like what's been already stated, I have been cooperating with the constituents of the mediation and everything. I have spoken with Taja about the custody battle, and up until like recently, which was like a few weeks ago, we've been trying to work things out, and I would like to see if we can work things out.
All right. Do you want to try mediation?
Yeah, that's fine.
All right, because we have a mediator with us today.
Okay.
All right. So I'll send you with Ms. Wiggins so that you all can try mediation. And then and if you don't reach a resolution on mediation, we'll come back, Ms. Groves, and I'll hear your motion for contempt. Gibson Spratley case. Ms. Marshall's trying to reach out to see, are y'all asking for, looks like one person asked for a breakout room, the other did not. Are we trying to go into breakout rooms, or I thought we were just looking at documents and making some determinations as to income? Or is that something you guys were trying to resolve?
That's why I wanted to see if there were some things that maybe we could resolve on that issue, and also on, after you left the bench, Ms. Gates said she wanted to deal with some other motions that she had pending. So I thought maybe we could try to short circuit thing.
What other motions?
So there are pending motions, Your Honor, and I did want to make several objections for the record. There is a motion to compel production of hearing transcript from the temporary hearing. There is also a motion for reconsideration of that order, and a pending motion for appointment of Garnett Litem. And once I say my full arguments, I'll be able to address the last two.
Yeah. So yeah, we're not starting this over. So that's not going to happen.
I'd like to know my objections for the record, Your Honor, when I have.
Yeah. Do you have a court reporter?
We do.
Okay.
I'm here at the top, Carla Hobson.
Which one? Okay. I'm sorry, I couldn't see you.
That's the court reporter that I asked to be present, Your Honor.
Correct. Okay. But are you participating, Ms. Gates?
Yes, I am.
Yeah,
Okay.
she said she was.
Excellent. Okay, so we can make this for the record. With this hearing right here is solely because there was when I got ready to make my final decision on the case on the income, there was a discrepancy or concern about how much money that your client made. And so to make sure that was clear, I indicated I would have opened up the evidence solely for that purpose. I'm not opening up the record for everything else. We're not trying it again because Ms. Gates Ms. Gates, because Ms. Spratley got an attorney. Because as you are probably aware, Ms. Spratley had an attorney before, then the attorney goes out, then she comes back, then she's by herself, then the attorney goes out, then she's by herself. And so she had the opportunity to have an attorney present, and did not have one present. So we're not starting all over again. Plus we had an very extended temporary hearings. And then afterwards, to be very clear, I asked them, okay, it took us, days to have those temporary hearings. How do the parties wish to proceed? Do you want me to accept that as final, start over? What do you want to do? And they both indicated, because they were exhausted essentially, for the court to accept the evidence that was presented in the temporary for the final. But however, that did not prevent anyone from bringing any new information or updated information, because we still had a final hearing and it still was substantial. And so even that final hearing, any evidence that they wanted to bring in new, or any information they wanted that was that changed any of the evidence that was presented in the temporary hearings, they had an opportunity to present. So we're not starting over again. It's just way too much time and energy spent in the case to even consider starting over. And with regard to the transcript, if there's a transcript, I don't have it. We don't keep transcripts, so there's no need to motion me. If there's a transcript, you can look in the file and you'll be able to see whether someone requested a transcript and if you participate in the transcript. And you can of course call that stenographer and get the transcript, because I don't keep them. I don't have any information to give you on that regard. But I do know I'm very, very specific about doing orders. So to the extent that there is a court reporter or stenographer attached to the case, you will be able to see it and you will be able to contact that person to the extent that you participated in the takedown. Most of the time she did not. So you would not necessarily have access to it because she did not participate in the takedown. But to the extent that she did and you can get it, that's no issue. But today, I want you to focus specifically only on her income, because that's the only thing I'm dealing with today. Okay?
And just for the record, Your Honor, I have filed a motion to compel production of the hearing transcript simply because opposing counsel has objected. I've requested, Ms. Bradley requested actually before I got on the case for a copy of the transcript so that I could confirm what Your Honor has just prefaced. And unfortunately, the stenographer said that she couldn't proceed because Ms. Brewer objected. So that prompted my filing of the motion to compel the production over counsel's objection, primarily because according to Giddings v. Starks, it's very clear from the Supreme Court of Georgia that you cannot allow for her to proceed on a waiver of a stenographer unless there is a very clear invocation of the Harrington rule. Opposing counsel has filed a transcript excerpt from the September 5th hearing. Even according to the excerpt, there doesn't appear to be any clear invocation of that particular rule. Likewise, from the conversation that was had, and at least clearly from the transcript itself, it says hearing excerpt concluded at 4:03 p.m. In parentheses, and this is on page 6, line 22. If it bears true that this conversation happened at 4:03, unless the hearing started at 4:03, Ms. Bradley wasn't advised that she's not entitled to a copy of a transcript, which is technically what the rule says she has to be until after the hearing concluded. That announcement, or rather that court's order, was supposed to be announced to her before the hearing started. My client's argument is essentially, Your Honor, is that she wants to make sure she has a very clear record. It's unfortunate that she has lost custody purportedly, and she doesn't have an account.
It's not purported. It happened. It's not purported. She lost custody. But here's the issue. The funny thing about your position, Ms. Gates, is that the case that's on the calendar right now had the very same issue that made this court change its entire position. The case that's in front of you, that issue came up before. And as a result of that case that just happens to be on the same calendar as yours, the court has a very, very strict process when you are waiving your court reporter. And
there's no court order.
I'm sorry.
I understand that may be the process, but the record doesn't show that. There's no order to that effect about her waiving her right. And again, the case law is very clear. It's not just about her saying I'm not participating, but it's more so about opposing counsel having the obligation, or the opposing party having the obligation, to invoke that she's not entitled to the transcript prior to her proceeding with the hearing. She was not advised of that in this particular hearing. And unfortunately, it's an injustice to her, and it's going to be extremely prejudicial to her if we proceed as a final for child support purposes only, and I don't even have entitlement to see what happened on September 5th. That's not my only argument, but that is just my first position as it relates to the transcript.
Yeah, it's not happening. Ms. Bradley is very aware, because this is not just the first hearing. We have had several hearings, and every hearing we go through this, and every hearing I say to her, are you participating in the tape count? Do you understand you will not have the record? And she understands that. I know she may have said something different to you, but it's clear she understands it. Okay, so you need to do what you need to do. I'm not stopping you from doing what you need to do, but I can tell you I'm very clear on that issue. Literally for almost, I can't express to you enough that I do everything I know how to do to make sure that they understand that when I start these hearings. Now, I'm not sure what excerpt was presented, and it is very likely we started a hearing on this case at 4 o'clock in the afternoon. So I don't know. I mean, it is not unheard of for me to start a hearing at 3 or 4 and go until 6 or 7 o'clock at night. So I haven't seen it. I'm not really certain about it, but I'm telling you that if she participated in the takedown, she would have it. And I also do, let me make sure, let me pull it up real quick.
You did do an order, Judge, on the
Usually I do.
You did an order on the 7th of September, and
That would have been after the hearing.
right, but during the hearing, Judge, you ruled that because Ms. Bradley was not participating, she would not be entitled to a copy of the transcript. That's what you ruled. And following that, you said you were going to enter an order accordingly, which it was 2 days before the order actually got filed. But the ruling was made there. Now, what Ms. Gates is trying to say is that I had to ask you to make a ruling.
You did.
I didn't have to ask the court to make a ruling because the court made the ruling without me having to ask that.
Well, then I will just give the citation for the record. Giddings v. Stark, Supreme Court of Georgia, 240 Georgia 496, says specifically that it requires invocation of the rule from you for you to pursue it, because the only reason we can't get the transcript is because you're objecting. The court has already stated today that insofar as she's concerned, we can ask for it, but you are objecting, and in order for you to utilize that objection to your benefit, you had to invoke the rule, and that was
that is not quite what I said. What I said was I don't have the record because we don't hold civil cases. We don't have court reporters for civil cases, so you have to bring a court reporter with you. When you bring the court reporter with you, you have to participate in the takedown. So we basically go on and go ask everyone. And you probably saw it this morning. Ms. Marshall comes on, asks who has court reporters, and asks who's going to participate in the takedown of that court reporter. And then I come back in and say, do we have a court reporter? They say yes. Are you participating in the takedown? They say yes or no. And then I say, if you don't participate in the takedown, here's what that means. Okay. So if your position is that and I do that generally for every hearing. Now, I mean, I got to go back and see.
Yeah, I mean, I understand, Your Honor. And if you are ruling against our motion, I would just ask for an order specific.
No, I'm not ruling against your motion. I can't rule against your motion because you were not noticed for that issue. This issue was noticed plain and simple for the child support matter. So I'm not ruling against it because I'm not entertaining it. That's what I was trying to tell you. You said you were going to make some oral motions, and I was like, nope, we're not doing
it. It's a written motion. It's a written motion. So I'm asking.
Or written motion. No, I'm not entertaining it because I'm not entertaining today because it's not noticed for today. So just like Ms. Brewer would have to have notice so that she could be prepared to answer and hear from you.
She's done a written response. So I don't know why.
Ms. Gates, make sure you understand me. Okay, I'm not going back and forth with you. I'm telling you, I'm not entertaining that today. I didn't say I would not entertain it, but I am letting you know I'm not entertaining it today. It's not going to stop this show today. So it's up to you. If you want to participate, fine, you participate. If your position is I'm not going to participate unless I have a full copy of the transcript, that's your position. But today I am going to hear and handle this matter. If you participate, excellent. If you don't, you don't.
I can state my position. My position is that this matter should be continued to the extent that she's not entitled to a current transcript and that motion hasn't been entertained. She can't get a full opportunity to attest any of the facts that have already been presented to this court at the temporary hearing if I don't have a ruling on her being entitled to the transcript.
Judge, Ms. Gates,
I do
keep saying
if I may continue. I do have another position on that issue, and I'm glad it's been prefaced. But the order that has been entered as it relates to custody is a temporary order. It says very specifically, temporary order transferring custody. Nothing in there mentions that custody has been resolved in finality. So I'm a little confused as to how we can proceed today without evidence on that issue since it hasn't been finalized. And likewise, under OCGA 91154, when more than one claim for relief is presented in an action, whether as a claim, counterclaim, etc., the court may direct the entry of a final as to one or more, but fewer than all of the claims or parties, only upon an express determination that there is no just reason for delay and upon an express direction for the entry of the judgment. There is no way Ms. Bradley is given a fair opportunity here. The way that this has been noticed, there's not an order with that express determination per statutory law. There has been no indication that this matter has been bifurcated per statutory law. She's not being entitled to the transcript per opposing counsel's objection, clearly. And I just, it's quite frustrating because to give her effective counsel, she should have the opportunity to proceed based upon Georgia law. And so far, I don't see that those things have been satisfied. Hence, why she's also filed a motion for reconsideration of the temporary order, which I suppose, and I understand the court will provide its response, but I suppose it's not going to also be addressed today, and a motion for guarding ad litem, since we only have the issuance of a temporary order. So,
yeah. So are you done with making the record?
Well, it depends on what responses I receive, Your Honor.
Yeah. Well, as I already indicated, we're moving forward today. Your position is that you're confused, which you probably would be since you were not.
I'm not confused. I'm sorry. I would just be clear. I'm not confused.
Well, you did say, you said confused. You specifically said you were confused
about. I'm not confused about law, and that
I didn't say you were confused about. I said you would be confused, and then you stopped me before I can finish my sentence. I was going to say you would be confused regarding the particulars of this case because you were not in it, and you did not see what was happening, and you did not understand the gracities and stuff that the court gave Ms. Bradley. So you might look at it a very different way, and I understand that. But what I'm saying to you is that your client is not confused because I try to be extremely thorough with regard to matters like this, and I'm telling you that your client was very aware that today, the only reason I did not sign a final was to give her an opportunity to bring her income down because the income sheet that we had previously was high. So I could have signed the order then, but I said, I'm going to give her an opportunity so we can see what her income is so that it will go down. Okay, because it was a higher income and she was saying she wasn't doing hair and things of that nature any longer. So that was the reason for me not signing the final order. And I specifically indicated that that was the only reason why I was holding the matter open. I had already made my final rulings in the case regarding custody, and I'm not changing it, okay? And we're not doing a guardian ad litem, and we're not starting over, okay? That's what I'm trying to say to you. So even if there was something in particular regarding the hearing that you're trying to look at, I'm not reopening it. It's just not going to happen. And I have the ability and authority to do that because she was noticed for a trial. She had an attorney, then she didn't have an attorney. And those were her. And I asked her, are you sure you want to proceed that way? She said she was. So what I'm saying to you is you can file whatever you need to file, do whatever you think you need to do. But today I'm finishing that issue on her income. So my question is to you, do you want to go in with Ms. Brewer to talk for a little bit? Or do your position is that you don't want that and that we're moving forward with the hearing? Which one do you want me to do?
Well, I've stated my position is that I believe a full hearing is.
All right, thank you, Ms.
If I can complete the record, if I can complete my argument for the record, Your Honor.
Ms. Gates, you made an argument for the record, and I asked you, were you done? So we're done with that.
You did not. You didn't allow me to finish, Your Honor, and I would like to finish.
Gates,
my position is I would like to proceed and represent my client on the child support issue.
You have two issues, two things you can do. You can go into a breakout room with Ms. Brewer, or you can have the full hearing. Which of the two? Because that's all you have.
A full hearing would be great.
All right. Thank you. We'll
come back. Ms. Gates, Ms. Gates is thinking you're talking about a full hearing.
No, I'm not. You can't read my mind, Ms. Brewer, but thank you.
I just want to make sure because from the very beginning.
One at a time, please. One at a time. I'm trying to make a record.
From the very beginning, I've tried to explain to Ms. Gates that we were here for a final back in September, that the order requiring us to appear was for a final, and there were but see what Ms. Gates is doing is she's relying on things that because of the fact that it says temporary. Well, I've explained all that to her, just like she indicated that I filed the excerpt from the trial in which you asked Ms. Bradley if she was participating in the takedown for the court reporter. She said, no, ma'am. You said, all right, you understand that means you'll not be able to use the transcript for appellate purposes. Yes, ma'am. And then you say, all right, so we'll do the order to that effect, Ms. Marshall, that the court explained that to Ms. Bradley, and Ms. Bradley has indicated she does not wish to participate in the takedown. So this is what I've been trying to explain to Ms. Gates for 2 months, and it's frustrating. needless to say.
Okay, I'm looking at the excerpt now because like I said to Ms. Gates earlier, it is generally customarily what I do. I didn't know that there was I didn't have an opportunity to look at it, so I'm looking at it now. Let me take a look.
And I would also like to note that it's only an excerpt. I don't.
Ms. Gates, please, 1 second, please. Okay, yeah, I actually did what my process is, which is to Miss Marshall comes out, see if they're court reporters. If they are, I ask if there's takedown. She prepares the order. She lets me know that there's a potential order for me to sign. I come out and then I put it on the record, because initially what I was doing was letting Ms. Marshall would do it. She would come out. It wasn't on the record. She would tell them that they would not have the ability to have it. And then another case that I had challenged that process, saying that the court needed to make the explanation. So as a result, I changed my process. We do the thing with which Ms. Marshall comes out and asks, and then I come back on the record while the court report is actually taking down and state, do you want to use the record? But I'm also telling you, Ms. Gates, so that you'll know, because you're going to go through probably other transcripts, and you're going to see I do it every single time for Ms. Bradley. And every single time I do it, and she denies it every single time. So even here, it says, as Ms. Brewer read, and I don't know if you had an opportunity to take a look at the transcript, but it says here, so I come on, it says, court, we're changing gears. I see that we have Ms. Trainer here, so I'm assuming you have a court reporter. Ms. Bradley, are you participating in the takedown for the court reporter? Ms. Bradley says, no, ma'am. I said, all right, you understand that means you will not be able to use the transcript for appellate purposes. And she says, yes, ma'am. I said, all right, then we'll do an order to that effect, for which I signed. So I don't know why, Ms. Gates, you're saying that you don't know what I said to her. It says it right here.
I didn't say I didn't know what you said to her. I can see it in the
Oh, okay.
But my point is about, first, the invocation of the rule for opposing counsel to sustain an objection of me getting a copy of the transcript, which is why I've asked the court to intervene in compelling it. And so, Your Honor, I understand that it may be a regular course for the court, but at this juncture, we still maintain our position in that the rule was not invoked by opposing counsel. And just because she has a private contract with the court reporter does not mean that she gets to intervene and simply say we can't get a copy of the transcript, because the court reporter acts under the direction of the judge. And so that is why we had to file it as a motion to compel.
Well, like I said, we'll deal with those motions later. Because I'm not going to, I spent way too much time on them when I said specifically 20 minutes ago that I wasn't going to address them. So we'll address those later, and we're moving forward. Even in that transcript, I'm very sure in that transcript, I made a final decision at the end. And then I said, which I'm sure Ms. Brewer probably said to you, I'm going to make this temporary to put a placeholder so that when the final goes out, if there's any concerns, if there's appellate purposes, that temporary order will stay in place. And that was the reason why I did that. I'm sure that's part of the transcript too, but I'm just letting you know. I know you don't have it, but that is what I did. And then I said, I was like, okay, on the issue of the child support, let me make sure that I have all these numbers. I tell you what, let me open up the record for that purpose only. Okay. And that's the reason I think we actually scheduled it for the following week. And then we had a continuance or something. Maybe the court had to reschedule for a trial, or maybe Ms. Brewer, I can't remember, but we had it the following week. And as a result of some continuance, it was moved. I think it's actually moved to another month later. And then something happened to that. And so that's why it kind of got pushed back.
So I think this is the next date, Your Honor. This is the date that you scheduled it for. I was not sure I was going to have internet
that's right.
access. So you continued it. And this is the very next date that the court gave us.
Right. That would be correct. I couldn't recall exactly, but I know that was the only reason. Otherwise, we'd have had it pretty much contemporaneous in time. It only got pushed off this far. So I don't want you to think, and I don't know what your client told you, I don't want you to think that we didn't have a final. We had a final. I just made a temporary as a placeholder because I needed this outstanding issue. And that's why the temporary was put in the placeholder. But just so you'll understand that, I didn't want you to think that there was no final. And maybe that's why you're asking for the guardian ad litem, because there was a final done. And we were in the middle of it. And we're basically, we finished all the evidence. It was just this one piece that's outstanding. I don't know if that's making sense to you or not, but that's what we're trying to do now. We're just doing that piece.
No, yeah, I understand the court's position. I am just simply referring to the record as it appears that there was a temporary hearing. So with that being said, whatever we proceed on today, I will be objecting to utilizing evidence from the temporary hearing. Likewise, I would ask the court to enter specific findings of fact and conclusions of law on whatever issues the court decides we proceed on today.
Yeah, you won't be doing that because you have to ask for that in advance, and you didn't before I started the trial, and you didn't ask for it. So so what I'm going to do now is we're going to go into we will, however, if your position is, I will accept your position that the court not accept any of the evidence from the temporary hearing, because I think that is one of those areas wherein you control it. So because the court cannot do that without you all coming to an agreement. So for that purpose, I will not accept any of that, and we will accept new evidence. That's completely fine. I don't mind doing that. So what we'll do now is I will start with new evidence. If you want to talk with Ms. Brewer, that's fine. If you want me to go straight into it, I will. Okay. What do you want to do?
We can proceed, Your Honor.
All right.
And Your Honor, if I could, the court, we had agreed in a previous hearing that we didn't have a court reporter at that time. That was back, I think it was around mid-February when you called us in to give your decision on the contempt issue. We agreed at that time that the court would be able to consider evidence from prior hearings pursuant to the Pace versus Pace. And then when we were in court on September the 2nd, you said, and this is on page 4, everyone agreed earlier that because we had such an extensive, and I do mean extensive temporary order, or it probably should have been temporary hearing. I think it spanned over a few days in general, but because we didn't do it consecutively, it spanned over a few months. And you said, in trying to deal with the temporary matter. And then of course we had the hearing and I signed the order, but apparently, and then you talked about the fact that the order was delayed. And then you said, back on the next page, I said, I brought it to the court's attention because I was just trying to figure out where the order was of something. Oh, that's on the other subject of the order. And let's see. You said parties have agreed. You said parties have agreed that the court can consider all the evidence that was part of the temporary. And that essentially today, I thought we were just here for kind of summaries. And then I said, no, that we, in addition to some summation or closing argument, we had additional evidence to submit. So we had an agreement, Miss Gates, now that she's representing Miss Spratley, she can't come back and say, oh, my client changed her mind. She agreed. She agreed.
Well, we would object to it. And
everybody, because they lose, goes and gets and decide that they want to redo everything and undo the agreements that they made that the court relied on and that my client and I relied on, then nothing ever ends.
Well, Your Honor, the other issue with this is that if it is the position that custody was finalized in September, I mean, it prejudices our client to not have an order that specifies that so she can have an opportunity to appeal within the 30-day time frame. Or
well, you can appeal any order.
Or if I can finish,
one second, Ms. Brewer.
You're correct, Ms. Brewer, but then she would have to proceed as an interlocutory appeal asking for certification from the court, and then we would still have.
That's not correct. That's not a correct statement.
Even if Ms. Brewer,
okay, you know what? You all, I'll see you all later. You're not. I'm not going to do it. Okay. So you all, I'm going to see you later on today. I'm going to focus on Horn versus Horn because for some reason, you all will not listen to me. So just take a moment because I need a moment. All right. And I will see you back later on today. Let me see. Horn versus Horn, 2 hours. I'll see you back at 1 today. Okay.
Okay.
All right. Thank you. Thank you.
Thank you. Give me one moment, please. Alina, give me a call. So let's
Yes,
begin there. So Ms. Brewer, I'm gonna, like I said, open up the evidence solely for the purpose of child support, figuring out Ms. Spratley's income. You may proceed.
All right.
Your Honor, I'm sorry, I know the court's about to go forward, but I just want to let the court know on the Allen versus Groves, if we can announce, it's a dismissal completely, but I just wanted to see if we could possibly get that in.
No, I'm not going
I
to
know you-
dismiss legitimation completely.
Okay,
You know, because without having a discussion, because not for the purpose of you dismissing a legitimation that could prevent from paying child support. No.
okay, so we'll just hold on. Okay, thank you,
Right.
Judge. Thank you.
That you were just speaking on that. You may want me to wait. I sent an order over and then I was asking for a compliance date, but I sent it to Ms. Marshall.
Okay.
Okay.
I'll do it. Like I said, I'll put it in the order that they're to pay those funds to you. And then I'll get you a compliance date as well. Okay. Ms. Marshall
Great.
has
And
it.
I sent a sample. She told me to send it in Word, so I sent it to Ms. Marshall. So I don't know Ms. Harris, Attorney Harris' email address to send it to her for your review or add, subtract, just to help out if I could.
Okay. Yes. Thank you so much.
Thank you, Judge. We'll call Ms. Bradley for the purposes of
Go ahead, Ms. Brewer.
cross-examination. Thank you. Ms. Bradley, you submitted, did you not, a statement from the Veterans Administration showing that your income is about $3,700, about $3,700 per month?
Yes,
What is the exact figure?
it's on the paper.
I'm asking you if you will testify to what the
I
amount
don't
is.
have the paper in front of me, so that's what I said, it's on the paper.
This $3,757. Does that sound familiar?
Yes,
I'm sorry, what was the number?
$3,757.
Okay.
Now, Ms. Bradley, how long have you you're getting a VA disability payment, is that correct?
yes,
And I think you previously testified that the nature of your disability was a back injury, service-connected back injury.
yes,
Now, that VA disability rating does not prevent you from being employed, does it?
yes, it does. It says it on the paperwork.
Can you point that out? Oh, you don't have it in front of you, so you don't know what you don't have the document. That's the paperwork that you're referring to. The paper.
Yes,
All right.
it says it on, I think, line 3 or 4.
All right.
100% disabled, unworkable.
When was the last time you were employed or had any kind of income from employment?
The post office back in 2020, I want to say 2020.
Now, tell the court, isn't it true that you're still doing hair?
No,
The basis of well, I'll move on. At this time, is your fiance still paying all of your bills as he's been doing the last few years?
I didn't testify to that.
You never testified that,
Not
that
for the
he
last
paid your
50
bills?
years, not since I've been getting my 100%. When I was fighting to get my 100%, yes, he was. But now, no. Why would he get 3,700 a month?
When were you actually awarded the 100%?
February of 2021. And they just back paid me.
But now he still lives with you, does he not?
Yes.
What is his contribution to the household?
Say that again.
What is his financial contribution to the household at this time?
What do you mean?
Does he pay your rent? Does he still pay the rent in the apartment?
Help with bills.
All right. Now, one of the issues that had come up was your inability to travel because of your back problems and the need to take medication. Is that correct?
Yes.
That's not been a problem recently, though, has it?
What do you mean? It's been a problem from day one.
Objection relevance to child support.
It does relate to child support, Your Honor, and that the court has indicated that at least 1 week in a month, you want Mr. Gibson to drive to Lithonia from South Georgia so Ms. Bradley can exercise her visitation and parenting time with the child.
Okay, and how does that apply to child support?
Well, it could mean that depending on the costs and expenses, it would, based on my client's testimony, we're going to make an argument that he's going to need a substantial deviation if he's going to do that because of the expenses that are incurred.
Okay, all right, sustain. I'm going to overrule the objection.
So, Ms. Bradley, you, for the last few periods of visitation since we came to court, you've been able to drive to Dry Branch and meet Mr. Gibson for the purpose of exercising a visitation. Is that correct?
No, I haven't been driving. Mr. Wright has been the one driving.
All right. So he's driven you on all the occasions?
Yes, sometimes by himself.
Now, you understand that Mr. Gibson has to bring your daughter to Atlanta once a month. It's going to involve him spending the night, correct?
I don't know what he got going on. I just know what the court order. I know the court order that he has to bring her the fourth weekend of the month.
Well, do you know what time your daughter gets out of school?
2:30.
So isn't it true that it's about a 6-hour drive, correct?
I'm not sure.
Well,
I don't know the distance from here to there. I don't know.
What's the distance from your house to Drive Ranch? How many hours does that take on a Friday afternoon?
On a Friday with traffic, about 2 hours and 40 minutes.
Okay, and Drive Ranch is
How far? You said 2
About-
hours.
Yes, ma'am, with traffic, because we fighting traffic coming out of Atlanta.
2 hours. 2 hours from your house to Drive Ranch. Is that what
2
you're
hours
saying?
and 40 minutes.
2:40.
Yeah.
And that doesn't even take into consideration the fact that Drive Ranch is really closer. That's really not the halfway point, is it?
Honestly, it's a 24 miles difference.
All right. You understand that, Mr. Gibson, if he brings has to bring your daughter to Lithonia once a month, it's going to be a substantial financial hardship on him.
No.
You don't?
No.
What would you be your proposal? When would you want him to bring your daughter to you and pick her up to take her back on Sunday?
Objection. If we're talking about finances, asking when he wants her to pick up and drop off, that's more relevant to what's already been ordered by the court. So
I'm going to say that.
It does have a bear. You know, I just would like to, for the courts, it does have a bearing on whether he has to spend 1 night in a hotel, 2 nights in a hotel. If he comes on Friday evening, it's clear he's going to have to spend 2 nights in a hotel. If he comes on Saturday.
That's an argument to be made. She doesn't have to agree to that. I mean, her position is the court ordered it. So it is what it is.
Ms. Bradley, how much have you paid your attorney to represent you in this matter, Miss Gates?
Say that again.
How much have you paid Miss Gates to represent you in this case?
I haven't paid Ms. Gates. My family and my fiance honestly have, but right about now we're probably looking at about $6,500. That's not even calculating today.
$6,500, and you've authorized her to file all the motions that she's filed. Is that correct?
Yep.
What are you asking the court to do as far as your obligation to pay child support?
I have no problem with paying child support for my child. I already paid, though we don't have a court order in place. Child support didn't in place. I sent $425 on the first of this month, just because I know eventually I'm gonna have to pay what I paid. Then I have to back pay whatever the court order. The difference of I went and paid like $425 because originally that's what it was when we originally did it a couple of years ago. So I don't have a problem paying for my child at all.
Now, you acknowledge, do you not, that Jalen was struggling and has been struggling in school for the last few years? Is that correct?
Say that again.
You acknowledge that your daughter has struggled in school for the last few years.
objection, relevance.
Yeah, what's the relevance?
Well, my client's going to testify that he's wants a deviation for education so he can get it. He's gotten a tutor for Jalen.
Yeah, that's something he can testify to.
All right. I have no further questions of Ms. Bradley, Judge.
All right. Ms. Gates, do you want to ask questions now or when it's your case?
I'll wait until my case. Thank you, Judge.
All right, thank you. Ms. Brewer, next witness.
We'll call Douglas Gibson.
Mr. Gibson, please right now.
Mr. Gibson, are you still employed by the United States Army in the same capacity you were in throughout the course of this case?
Yes.
And tell the court your distance between your job and the home where you reside. How far is that?
It is about an hour and 25 to 30 minutes on average due to light traffic.
On a Friday afternoon, what's the approximate drive time on Friday afternoon for you to drive from Pierce County, where you live, to Lithonia?
That traffic, with that Friday evening traffic, I'll probably be looking at anywhere over 5+ hours as far as trying to get into Atlanta, coming from this area.
What time does Jalen get out of school?
She gets out of school normally around about 2:30 or so.
And assuming you left within an hour after she got out of school, what time are you estimating that would put you in Lithonia?
Objection, Your Honor. I don't hear the.
It would be.
Sorry,
I'm
one
sorry.
second.
My
One
objection
moment.
has to do with the fact that counsel is questioning more so about distance and time as opposed to, if she's going to argue for some sort of deviation, I would have expected the questions to be about the finances of that travel as opposed to the distance.
Yeah, I'm gonna overrule your objection. Make it proceed.
What time would you expect to arrive in the Atlanta area on a Friday evening?
It would be, I would say, pushing anywhere between probably about 10 o'clock. That's depending on, once I get off and then I take that drive and I get home to be able to get on the road to pick Jalen up, it would probably be closer to 10 p.m. And that's getting straight off from work, coming straight home, getting on the road.
Now, assuming you are still going to be required to bring her to Atlanta, have you looked at how many nights you would have to spend in a hotel if you come in on a Saturday, on a Friday night?
So if I came on a Friday night, I would have to stay that Friday night plus that Saturday night to be able to depart that Sunday to head back with Jalen. So I would have to stay a total of 2 nights.
And would you also have to leave Atlanta early enough to get Jalen back to school at a reasonable time, back to your house at a reasonable time?
Yes, with it being that Sunday traffic driving the full stretch, still looking at that 5 to 6 hour window all the way back to Dry Branch. So I would definitely need to try to arrive back home no later than 7 p.m. 7:30 at the latest, so that way I can make sure she's fed and of course showered and ready for the next day, and whatever she may need.
Now tell the court what kind of vehicle do you drive?
So right now I have a 2010 Camaro, and my wife has a 2011 Toyota Camry.
And with your car, the Camaro, tell the court please how many miles you have on it.
So my car has about 220,000 miles on it.
And what about your wife's vehicle?
It has 324,000 miles on it.
Is it fair to say that, well, tell the court what your plan would be if you're required to do this, what plan would be regarding a vehicle to get your daughter back and forth?
So to be honest, as far as reliability, to be able to get her there on time and meet the requirements, it would definitely require a reliable vehicle. And if I were to have to get the vehicle, it would have to be on a Friday and a drop off on Monday, due to here in Waycross and the surrounding areas, they don't have a 24-hour drop off. So I would have to drop it off on that Monday, which would cause me, of course, to miss work to try to return a rental vehicle.
Now, if the judge says come on Saturday to pick her up rather than Friday, would you still have that 3-day rental window for the vehicle?
Yes, I would still have to try to pick it up that Friday to be able to make sure I'm there that early morning on Saturday. It'll be a 1-night stay. And then, of course, all the other requirements, and to be able to still get back at least a grace period of 6+ hours. So no later than 12 or 1 o'clock, I need to be on the road leaving Atlanta to get her back at a reasonable time.
If you would, Mr. Gibson, could you pull up Plaintiff Petitions Exhibit 2025?
So this is pretty much a outline of what a fourth weekend would look like if I were to have to take school.
There's an objection on the floor.
Yes, just before it's published, if we can lay the foundation. I just want to hear what it's for before being published and tendered to the court.
All right, lay the foundation, Ms. Brewer.
Tell the court, please, what this is before you page down. Tell the court what this document is, please.
So this document is a cost estimate or cost analysis of what it would require of me to be able to make that drive 1 weekend a month to Atlanta.
All right, Your Honor, we tender Plaintiff's Exhibit 25.
All right, any objections, Ms. Gator? It's just for
demonstrative, yes. No objection. Thank you, Judge.
All right, 1 minute.
Okay, Mr. Gibson, let's see what conclusions you came to. Did you price the hotels in the area?
Yes.
And tell the court, you can page down now if you'd like. Tell the court which hotels you looked into.
So I checked around the Lithonia area, pretty much tried to stay in the area within where I would be dropping Jalen off, or a little south of there, or even consider a little further north, just trying to make sure I would be within distance upon departure. So.
And what did you come up with in terms of the price that the hotel would be for Friday and Saturday nights?
It would come out to about roughly $400 or so.
All right. Could you page down and show the exact amount of that's 2 nights. Is that the 425.29?
Yeah, 425, 28. Yeah.
And which 28? Which hotel was this for?
This was the Fairfield Inn Suites. This one's right here in Stonecrest area.
All right, tell the court what else you found in this, in your search for, figure out how much this is going to cost, these weekends are going to cost.
Okay. Also, I just did a estimate of roughly having to pick a vehicle up on that Friday, once I get off work, for either a Friday or a Saturday departure to Atlanta. And of course, just compact vehicle. I'm looking at easily $228 for those days with a $300 deposit from Enterprise.
And did you also have an estimate for gas and food?
Yes.
Tell the court about that.
So as far as the travel distance, it is roughly 200 miles each way, there and back. So that's roughly about a full tank. So I estimated around $60 or so for fuel, and just to be able to get directly there and back.
All right, so you're saying round trip fuel, $60.
Yes.
And what about food?
As far as food, I came up with a ballpark number. It was right around 120, and that was right under $10. You know, breakfast, lunch, and dinner to be able to get there and sustain until it's time to depart with Jalen.
You asking the court to take those figures into consideration and those expenses into consideration if you're required to come once a month to bring Jalen to Atlanta.
Indeed, because that is actually going to put me in a serious financial bind and more than what I'll be receiving in Jalen's child support.
Now tell the court, Jalen is enrolled in school now in Pierce County, is she not?
Yes, ma'am.
And the court's already aware of the educational difficulties she's had. Has she been evaluated since she's been there in school?
Yes. So roughly about a week or so ago, she took her benchmark test. And her reading, she scored a 57. In math, she scored a 34. In science, she scored a 51. So right now we're having to move at a pretty fast pace to get her caught up.
Have you looked into the cost of tutoring for her?
Yes.
And what's the hourly rate that you've been quoted?
So right now I'm looking at about $60 per hour for this area. And that is roughly, I was looking at 2 hours per week as far as like each subject for the reading and the math. The science, we're definitely working with her on all three areas, but she's starting to grasp and get a hold of the science. But her biggest issue is reading comprehension, which plays a major role in any academic that she actually tries to, tackle. So that's her biggest issue right now.
And so you would like the court to consider 2 hours per week at $60 an hour? It's $120 a week?
Yes. Yes, to try to get her that additional time in tutoring. Me and my wife, we definitely spend hours in a day. Sometimes I even bedtime on the weekend. So she's pretty much on a pretty structured schedule here as far as time going to bed and study habits. So we're just trying to get her in the rhythm of things, but that tutoring would be an addition.
Have you already pinpointed a tutor?
Yes.
And has Jalen actually started with the tutoring yet?
No, so I spoke with her. Jalen will be able to start next week, starting on Tuesday.
So it's Tuesdays, and would she do an hour on Tuesday and an hour on Thursday? Is that how you planning?
Yes, yes, ma'am. She'll be there on Tuesdays and Thursdays.
And is this tutoring going to be in person or via Zoom?
This will be a virtual on a Zoom call.
Mrs. Gibson, as far as the other weekends, the second weekend when you actually meet in Dry Branch, what's the distance between you and, well, is Dry Branch the halfway point?
So Dry Branch is not the halfway point. At that point in time, the judge had me to drive further to accommodate Spradley's time in traffic. So I drive roughly an extra, I want to say 40-ish miles or so. So I've been taking the long end of the drive from day one since that decision was made due to traffic.
And since we haven't flashed out the details in terms of when and how, have you pinpointed a halfway point?
Yes, I was able to find something that is a lot closer, which would be exit 42 in Dudley, Georgia.
Do this. I've already indicated what we're going to do. We're doing the same drop-off points. It's the same. This is not new. This is not something I'm doing. We're doing with child support. That's it.
Okay. And Mr. Gibson, I think you've submitted your financial information to opposing counsel, indicating that your annual salary for last year was $66,298.44. Is that correct?
Yes, I sent over all the documents. Yes.
And your present monthly income is $5,524.87. Is that correct?
It's right around there. Somewhere, yeah, somewhere around, right around
So
roughly 6.
you're asking that the court give you a deviation for number one, the tutoring, and number two, the travel, if you're required to come to Atlanta, as the judge previously indicated.
Yes, because it'll actually be putting me in the negative. Trying to make that drive once a month, definitely.
So I think based on your testimony, we're looking at expenses somewhere, the travel expenses somewhere in the neighborhood of $800 per month.
Yes, somewhere around
You
700-800.
everything up. All right. Thank you. I have nothing further this time, Mr. Gibson, Your Honor. We would just go ahead and, well, we've tendered 25. We would go ahead and tender, well, let me ask him to identify 24.
Pay stubs and pretty much overall overview of my monthly income from the Army.
All right. Thank you. We have nothing further for Mr. Gibson, Your Honor. We just got like to tender plaintiffs 24 also.
I'm gonna go back. No, go back down.
Okay, sorry.
This is your 2022 W-2.
Yes, this is the W2.
Indicating 62,298. Now this W-2, what is this for?
These were documents that was requested from the other attorney as far as the pay stub.
Is this for work, military? What is it?
This is for military. I only have one source of income, Your.
And that's military?
Correct.
Do you recall when I was asking you, and I thought you told me that you were on the cusp of retiring and that you would be basically have the time and energy to stay at home with your daughter, and that was one of the reasons why you initially indicated that you thought you would be a good parent. Do you remember telling me that?
I did, Your Honor, and that's actually what's going on right now with the process.
So when you told me that is the consideration the court indicates that you have time. Now you're telling me you don't have time to make, essentially, you don't have time to make the drop-offs, and that it's going to be considerable income deficit for you. So I'm a little confused.
As far as the income, Your Honor, that full drive.
That if you said if you had to leave on Sunday, you'd be concerned about missing work. But I thought your position was that you were transitioning, you were about to retire, and that you have the time to submit to getting your daughter up to speed and making sure that she's not home. I mean, those are some of the, well, that was a significant consideration, but you're telling me you're not retiring.
Yes, I'm actually retiring right now, Your Honor. As far as the medical process, I'm going through the medical evaluation.
Can't
so
see.
that is, okay, sorry.
Yeah, take that out.
Okay, can you see me now, Your Honor?
I can. Mm-hmm.
Okay, so right now where I'm at, I have roughly probably about a 6-month window or less. And that was only due to me having to go past 20 years due to some injuries that I've occurred since I've been in the Army. So I have not had a chance to get those taken care of. So that's the only reason I have not actually retired. I had an injury that needed treatment. So now I'm actually getting ready to go through the medical transition process out of the Army. So during that period, in roughly the next 6 or 8 months, whenever that medical retirement is complete, my pay will go 50% of my base pay. So instead of making $6,600, I'll be making about $2,700 for a 20-year retirement at 50%.
Okay. The amount that you're showing on there, does that amount take in consideration housing and things, the different considerations you have by being in the military?
As of right now, it does, Your Honor. But once I'm retired out, like I said, the only thing I will receive at that time will be the compensation that I've earned for 20 years of service, which would be 50% of my base pay. So once I've done the math, I came up with about $27,3660.
Okay. Okay. Ms. Felder, have them across.
Mr. Gibson, can you stop sharing your screen? Because we see your screen.
Okay, sorry about that.
That's probably, yeah, that's why it feels so weird.
Okay, I don't know if you can see me or not.
Thank you. All right, Mr. Gibson, have you provided us with a domestic relations financial affidavit?
Yes, that should have been sent over with the other documents from the attorney.
All right. And did you file a domestic relations financial affidavit with this court?
I think I filed maybe 1 or 2 previously, and again think the beginning of this case, I can't remember the exact time frame, but I think at least 2.
Okay. I can show you what your counsel did not tender, but what she marked as Plaintiff's Exhibit 14 for your recollection. I may share my screen for his recollection, Your Honor. Is this a accurate copy of the domestic relations financial affidavit that you've provided to us and likewise filed with the court?
Well, let's see. Okay, yeah, this should, okay.
All right.
I don't know when it was.
Sorry. Right, is that your signature?
Okay, yeah. Yes, that's my signature. Yes, that's one of them. I've done
Okay.
a couple of them.
And that's dated October 14th, 2023, correct? I don't know what that is actually.
2022, probably.
I don't think that's this
Okay,
year.
2022. Okay. All right. So at least for argument's sake, this is an accurate copy of a domestic relations financial affidavit you've provided to us, correct?
Yeah, to my knowledge, yeah.
Okay. All right. And according to this financial affidavit, you make $7,313.20 gross monthly, correct?
That's before taxes, yes.
Okay. All right. Now, likewise, according to this financial affidavit, you have plus 44,000 in assets. Isn't that correct?
Let's see what we got. So of course I have the home, furnishing. As far as the automobile, right now I'm pretty much that 28 wouldn't be there. Can you scroll up some?
Mm-hmm.
Let's see. No, that 3,000. That's no longer current. So yeah.
So tell us which car, your car or your wife's car, is worth $28,000.
So I originally paid 28,000 for a vehicle. This was 2000 and late 2011. That was the 2010 Camaro that has the 200 and some thousand miles on it.
All right. So according to you,
probably valued at probably about 5,000 right now.
okay. Well, this was not more than a year ago. So last year your car was valued at $28,000. Correct?
That's what I put as far as thinking that that's what was the cost of the car. Maybe I misspoke that because that's what was paid on the car in late 2010, 2011. It doesn't hold a value of 28,000 today for a 2010 Camaro.
Okay. Well, this is your affidavit, sir, and this is the amount that you claim your car was valued at. So my question to you is, according to this affidavit, your car was valued at $28,000. Isn't that correct?
When I first purchased the car, upon purchase in 2000.
My question is, it's a yes or no question, sir. According to this financial affidavit that you swore under oath was true, in just October of last year, your car was worth $28,000. Isn't that correct?
No, it was not. I guess I misinterpreted what was supposed to go there, the cost instead of the value. So
I think
that was.
I don't think I'm making myself clear. That's your signature, right, sir?
That is my signature.
Okay, and you swore in front of a notary public that the contents of this financial affidavit was correct.
Your Honor, I'm going to object. I think the question's been answered.
I don't know the point of the. I think yes, I agree. It's been answered.
Okay. Well, I guess I think I'm a little confused because, Your Honor, he said multiple answers, so there hasn't been a clear answer. First, he said it was worth $28,000 when he bought it, but then he also confirmed that this was his signature. It's his notarized affidavit, which is dated in 2022, and that in this affidavit specifies that the automobile is worth $28,000 plus. So is he refuting his affidavit because he hasn't been clear in that?
Yeah, I think that's what he was saying, but you can ask him the question again.
All right. So my question was, according to this affidavit that you notarized and that you swore to as accurate, your car was worth $28,000. Isn't that correct, Mr. Gibson?
No, it was not worth 28. I once again put what I paid for the car. I have the VIN number. I can do a Kelly Blue Book on it, and like I said, with that kind of mileage at 222,000 miles, the car is roughly about 4,000 or 5,000 on value.
Is your car drivable, sir?
Not at this time, it's not.
Okay, and did you provide the court with any information concerning the operation of your vehicle?
No information actually was asked as far as the vehicle. It just went down actually about a week ago because I was driving it prior to. Just had an issue with it. So
And it's gone down. Why?
right now there's maintenance issues with it.
Okay. What kind of maintenance issues?
So right now it needs, of course, some tires and a starter. The biggest thing is the starter needs to be replaced, and I think that was the biggest thing. The cooling system. I just need to have the cooling system checked.
Okay, and you've provided us with proof of your income of at least last year, $62,000, $62,298.42, correct?
Yes, ma'am.
All right. Do you anticipate getting a new vehicle?
Right now, we're going to have to purchase a new vehicle at some point, just due to the nature of the mileage on these cars. So these are things that I'm definitely trying to get in position to purchase the new vehicle. Also, with the exiting from the military, I have to be financially smart. That's why I stated to the judge, me taking that one weekend a month to travel the full distance would actually put me more in a bind once I go from roughly 5,000 to 6,000 per month to half of that.
If you get a new vehicle, you won't need a rental car, isn't that correct?
Yes, but I am working on trying to get a new car, but that I'm not in a position at this time. So that's why the rental is the option of choice at this time.
And you say your wife has a vehicle that's operative, correct?
She has one car with 324,000 miles on it at this time. I do my best to try to keep the maintenance up on it. But with a car at that limit of 300, it has pushed its self over the hump. So I don't know how much life is left in that car.
Is it operative?
It is at this time, yes.
So you can choose to use your wife's car. You can choose to buy a new vehicle. And in that instance, you wouldn't need a rental, correct?
I cannot purchase the new vehicle at this time. That is why I said the rental car would be the option I would have to take. If I had the funds right now to go out and purchase a new vehicle, I would.
You could use your wife's car. I think you answered part of the question, but not the full question.
That is what we have been using. You can verify that with Mrs. Spradley and her fiance. Pretty much on every pickup and drop off, I'm in a gold Toyota Camry. That's my wife's vehicle with 324,000.
All right. And have you had to, since the entry of that temporary order, have you had to drive to Lithonia?
Since the order, I have not at this point. And we've been trying to get this ironed out as far as the details of this fourth weekend visitation, because there's a lot of things that are underlying that we didn't have time to iron out when the judge made the ruling. It was just kind of like, hey, we were going through trying to get everything ironed out. But the underlying issues as far as time, constraints, travel, traffic, none of that was considered at that point in time. So that's why my attorney has been trying to communicate with yourself so we can get the best solution between myself and Mrs. Spradley.
Okay, so you haven't had to actually stay at a hotel since the entry of that order, correct?
No, I have not.
Okay, and you haven't had to actually rent a car since the entry of that order, correct?
No, I have not at this time.
Okay.
Have you done drop-offs yet?
So yes, we've been doing drop-offs in Dry Branch, which is right outside of Macon, roughly probably about 15, maybe 20 miles off of 75. So right now we've done the second weekend drop-off where I meet her at the gas station in Dry Branch.
Judge, this is the first weekend. This is the first fourth weekend since the order was entered. So this would be the first weekend that if he has to come, he would have to come tomorrow or Saturday.
So the 1 week in a month is on the fourth weekend?
Yes,
Okay, so this is the weekend that he would travel.
this is the weekend.
Yes.
Okay. All right.
Okay. All right. Now for the tutoring, do you have an account statement or anything else that proves the cost of the tutoring?
Yes, so I actually have Ms. Nicole. She's actually going to be emailing that over to me, and I was going to share that with Ms. Bradley on OFW.
Okay, so Ms. Bradley hasn't seen it and you haven't tendered it to the court today, correct?
Not at this time.
All right.
I just had the acceptance where she told me she will be starting on Tuesday of next week. So all information, I make sure that I communicate with Mrs. Bradley and keep her informed. So it's no, I don't hold any information back.
All right. And are you aware that Ms. Bradley also had to pay for tutoring for your daughter?
I'm not sure. She said supposedly, I never seen anything that she was in tutoring, so I'm not sure.
Okay. All right. That's all.
Just a few questions, Judge. Mr. Gibson, the tutor, was your daughter in some kind of school-related tutorial this past part of this past school year? After school tutoring?
Miss Bradley said she was in some type of tutoring, but I don't know if it was. I was under the impression the way it was explained was it was through the school, where she would hang out after school and the teachers would give her additional help. I was not aware she was, making payments or anything of that nature.
And are you going to need the ability to rent the hotel and pay for the rental car if you're going to be in compliance with the judge, but in order to be in compliance with the judge's order?
That is definitely a hard yes, because I mean, right now if I would have to fork that $700-800 out on the fourth weekend, and then of course travel on the second weekend, I'm blowing probably $1,000 in 2 weekends out the month between getting her there on the second and then trying to accommodate a fourth weekend.
Thank you. Nothing further.
Just really quick, Cross, Your Honor, just since they re-mentioned his capability of being in compliance. You stated in your earlier testimony that it takes an hour and 25 minutes to get from your home to Lithonia?
No. From my home to Lithonia is almost about 5+ hours. I live in Blackshear, Georgia, literally Waycross, Georgia. You can Google it from Blackshear, my address to 100 Committee Lane, Bradley's address. It is about 200 miles.
Okay, and in order for you to, I'm sorry, because I guess I'm confused. There was a period of time where you said it was an hour and 25 minutes. Was that in reference to Dry Branch?
No, so what you're responding to is as far as my distance from home to work. From home to work, correct.
Just FYI, I'm doing a quick Google search and I do see that from Blackshear, Georgia to Lithonia, it's approximately 4 hours. And so today your testimony is that it would be 5 hours. Is that correct?
So once you consider all the traffic on I-16 and the evening traffic on a Friday in Atlanta, we're looking at well over 5 hours at least. And that's that probably what? Probably by the time I get up.
Yeah, I'm sorry, if y'all will hold for one moment, please. You may continue. Ms. Gates.
Yeah.
No, you may continue.
All right. All right. You agree, Mr. Gibson, that you only have to travel to Lithonia once per month, correct?
Yes, if that fourth weekend would be once a month.
Okay. That's all, Your Honor.
Okay. Do you have any additional questions for Mr. Gibson?
No, Judge.
All right, then. Ms. Gates, you indicated that you might want to call your client.
Yes, Your Honor.
Mhm.
Very briefly. Miss Bradley,
Yes.
you've been sworn. I think you've been sworn and you're still under oath. All right. Is your disability income your only form of income?
Yes.
All right. And how long have you been on disability?
I actually been getting it since like 2019, but I didn't start getting my 100% until October of 2021.
Okay. And you've heard Mr. Gibson request a deviation for travel. Since you all have exercised any visitation, has he traveled to and from Lithonia?
No, he have not.
Okay. And do you believe that this is a financial expense for him or an argument of convenience?
I was arguing for the convenience.
Why is that?
I mean, because originally, as the just pointed out, he made it as if he had the time to reference the support to do whatever he needed to do in reference of getting Jalen and doing whatever the court would desire of him to do. So now that he has there is now stipulations of me paying for rentals and hotels. Forbid I've had my Jag have been in the car. I mean, the shop at one point for a whole year. And so for the weekends that I had to take her, I was renting cars, but I didn't ask him to pay for them. I did what I had to do because that was court order.
Right.
So if you take on that responsibility, and that's what you told the judge, that's what you told the court, that's what you've been saying for years. Now we're here. Now you want me to pay for the inconvenience of you.
Mm-hmm. All right. You've also heard he's asking for a deviation for tutoring. What are your thoughts on that?
Okay, so I know we can't go back into it, but Jalen had been in tutoring from 3rd grade. So she did 3rd and 4th. She actually did last year, she did a whole year in tutoring just for school for the Georgia milestone because, as I said previously, I knew she kind of struggled in reading and language arts. And it's not that she can't read. You know how you read and you don't comprehend. Like if I read a passage, she can't tell you what she just read. So it's more reading and understanding.
Right. This line of questioning is not helping the court. It's not going to help me with child support. Mr. Gibson indicated to the court that if he had Jalen, he would put her in tutoring. And that was something that he did not need assistance with. So you can move on. Something else.
Okay. Well, that's all, Your Honor.
Mm-hmm. Okay. So you can't go back on the stuff you tell me, Ms. Gibson, because that's what those are the things that the court took into consideration. You told me you did not need help. That's what you said. Okay. All right.
I wasn't expecting. Oh, no, no.
Okay. Well, you took up 20 minutes of my time discussing it.
I can't hear you, Judge.
Never mind. It doesn't matter. Okay. Anything else, Ms. Gates?
No, just argument. Thank you, Judge.
All right. Argument.
Judge, I have some questions that didn't come up in my original cross-examination, just a few.
Okay. It must touch on what she just asked. Can't be anything else. Yes, if you have it, based on what
you indicated that you've been getting your disability since 2019, but that was never disclosed in your in the previous case.
What do you mean?
You never disclosed in the previous case that you were getting disability income. You only disclosed your income for the from the post office and doing hair.
I did disclose it when that was when I was on the self-folding. I think this was before your time. And my 100% just didn't kick in until October of 2021 because yes, it was disclosed. That was just before your time as his lawyer in representation.
And you've never filed a financial affidavit in this case at all, have you?
I want to say I have not.
Thank you. Nothing further, Judge.
All right. Actually, I have a hard stop now. I got to go into yet another hearing. I have an actual in-person hearing that I need to do. So I've asked everybody to return at 4:45. Ms. Brewer and Ms. Gates, do you have argument or?
We do, Judge. And
okay,
and although I know we're here on the limited purposes of the child support, but there are some things that need to be worked out as far as times and meetings, all that for the fourth weekend. that
I
was?
mean, not really. I'm gonna do those things. That this is the court's judgment. So I've already indicated what I was gonna do, and I've already given consideration to that. The only thing that I needed was the amount of child support, because honestly, I was under the impression that Mr. Gibson kind of gave to the court that he really did not need help. That was kind of the understanding that I had.
But Judge, he didn't know that he was going to be required to come and spend the whole weekend in Atlanta in order to bring the child here to Miss Bradley. You're concerned with her.
He can file a motion for reconsideration later. He can file a motion for modification or whatever he needs to do. But that is what I'm going to do. So I'm not going to reopen the evidence to go back over. I gave you what I was going to do, and now you're going to challenge it.
That's not what I'm saying, Judge. All I'm saying.
What I'm saying, I understand what you're saying. What I'm saying is, I told you what I want to do. You don't now get evidence to show me how it should be done. I already know what I want to do. So what I'm saying, I need to write it out. And if you don't like it, you can ask for reconsideration. You can do those things, but I'm not going to take evidence on it. I already understand his circumstances. I knew how far they were apart. I knew those things already. So
my only point is that at least for the second weekend visitation, we know what the schedule is. We know what the meeting place is. For the fourth weekend visitation, we don't have a schedule. We don't have a time that they're due to meet, a place that they're due to meet, what time it is.
You're right, because I haven't written the final order.
All right. Okay. So you're going to include, but we just at least need to know what's going to happen tomorrow. And
well, like I said, initially that I would have had that written out, but we moved the date.
I got it.
Why you don't have detail in it, because the date got moved, and so we didn't do the final in that time frame. And so when we actually got it done, which is today, we're butting up against that particular, and that's why we're kind of finding ourselves here. But I understood that there might be some hardship on Mr. Gibson, but because he was in the retirement phase, my thoughts were that he had a little bit more time to move things around. And Ms. Bradley was indicating that she was having pain and hardship and can barely move. That's what was presented to the court, and that's what I accepted. So I'm not going to open up the evidence. I'm not opening it up for Ms. Gates, and I'm not opening it up for you. Okay. So what we're going to do is I'm going to write this order. Okay. And if you have some issues with it, you can take it up when you see it. Okay.
To that end, do we need argument, Your Honor? I mean, Ms. Brewer, do we really need to turn it 4:45?
Deny her a small argument on this issue. If she wants to do it, that's fine. I'll see you back at 4:45.
Okay. All right. Thank you, Judge. I'd like to waive opening, reserve the right to close.
All right, Ms. Gates.
Yes, Your Honor. I have formulated a child support worksheet based upon the party's income per my proposed child support worksheet. I am asking that the court place Mr. Gibson's income based upon at least the 2022 W-2 that he's provided, which would mean his monthly income is $5,524.87. Ms. Bradley has testified very clearly that her only income is her disability, and thus her monthly income is $3,757. I am not asking for any deviations from what I understand, and the court may have heard this, although I didn't hear it today, but
what amount of child support again?
The bottom child support is $478, with Ms. Bradley being considered the non-custodial parent.
Okay.
Yes, Your Honor. I don't have any deviations, nor do I even have credit for health insurance. Neither party testified about health insurance, and even if so, I believe the child had TRICARE. Nonetheless, Your Honor, in regards to the tutoring expense, it's very clear that Mr. Gibson makes more than Ms. Bradley. Mr. Gibson can certainly elect to put the child in tutoring. To that extent, Your Honor, if the court deems it appropriate to make the parties share in any types of expenses, whether that be tutoring, extracurricular, or uncovered medical expenses, I am asking that it be based on pro rata share of their incomes. So that Mr. Gibson would be responsible for 60% and Ms. Bradley would be responsible for 40%. So if that's the case, the party who pays the expense can provide proof of the payment or invoicing to the opposing parent and, the other parent, and that parent can reimburse within 15 days, Your Honor. As it relates to the travel deviation, I don't believe that there has been sufficient reasoning as to why a travel deviation is needed. I don't believe there's been any testimony specifically today about how it relates to the best interest of the child, at least, because if a travel deviation is going to be placed into the child support worksheet, the court would have to make specific findings as to, at least among other things, how or why this would be in the best interest of the child. So with Mr. Gibson's testimony, he's essentially saying that he's going to have to stay in a hotel and he's going to have to rent a car. However, his testimony is a little contradictory in that he's saying that he has 2 potential vehicles he can use, and likewise he may even have a vehicle that he will purchase in the future. And so we don't have any clear evidence that he will definitely utilize this as an as his option, and he shouldn't thus be entitled to that travel deviation, changing the child's child support amount based on that, or deviating from the presumptive amount based upon his option or election to either use his own vehicle, which he has testified, at least his wife's vehicle right now is operative, versus a rental car. So I don't believe that that would be sufficient evidence of his travel expense moving forward. Likewise, having to stay in a hotel is going to be very variable in nature as well. I still don't believe I've heard sufficient testimony that he would definitely have to stay in a hotel, to the extent that it may be a long drive. I do understand the court has verbalized on the record that he stated in previous testimony at some point that he would not need help. So to this end, if he is going to assert that he have primary custody and the court has ordered that he be able to travel to Lithonia at least once per month, I don't see any reason why he would need help in doing so. But primarily, I just don't believe that there's been sufficient evidence or record of him actually doing so. So without sufficient evidence as to an actual travel expense, without sufficient evidence as to knowing for certain that this is his expense that he's going to attribute every 4th weekend, I don't believe that there's sufficient argument to deviate from the presumptive amount. So we're asking that the court utilize the presumptive amount of $478 if the court has already decided Ms. Bradley not have custody of the children.
Okay, Ms. Brewer.
Thank you, Judge. Judge, you know the history of this case. The court has made every concession, given Ms. Bradley every opportunity to co-parent, years of violations of orders, interfering with my client's visitation, disrespect towards him in the presence of the child, refusing to deal with the child's emotional, educational issues, including not sending the child to school and not getting the child to school not getting the child to school on time when she did go. And and that's just that's just the tip of the iceberg with all of Miss Bradley's violations and what has brought us to this point. And finally, my client's awarded custody, and he was prepared to carry the lion's share of the load, but he can't carry everything. He can't. The issue of the tutoring that we talked about today, he's known the child needed tutoring. Miss Bradley knew. The previous testimony indicated Miss Bradley had the child in a after-school tutoring program, which clearly did not help since the child is still struggling. But Your Honor, the issue of the tutoring probably would not have even come up in terms of us asking for a deviation or to be considered for deviation for that until the court ruled that he was going to be required to bring Jalen to Lithonia once every month. And at the time the court, made that ruling, we didn't have a chance to think about it, or it was late in the day, as opposing counsel has already indicated. But when we're looking at it, Mr. Gibson works. For the time being, he is working. He has a job that he has to be there and on time. He has to work all day. He has to pick up a vehicle, and opposing counsel is saying that we have not established a need for a vehicle. But if he has a car with 220,000 miles on it, and his wife has a car with 325 plus miles on it, it's clear those cars cannot make it up the road to once a month to Dry Branch, but then on the 4th weekend all the way to Lithonia. So we believe we've shown that so what he's got to do is he's got to work all day, pick up, get a vehicle, get Jalen out of school and ready for the road, drive 5 hours plus on Friday evening to get from South Georgia to Lithonia, and then spend 2 nights here. Well, I'm not sure where he's supposed to spend the night on Friday night and Saturday night. He doesn't live here. He lives in near Waycross. So he's got to spend the night here. And I'm not sure that that's something that the court necessarily took into consideration. Of course, we didn't have that conversation back on September the 5th. But he's going to be incurring substantial expenses. He testified that it's looking like it's probably going to be $800 per month. And opposing counsel argues that has not expended that. Well, he hasn't expended it because this is the first 4th weekend since the court rendered its ruling. So because the last 4th weekend was the weekend that Ms. Bradley turned Jalen over to my client. So this is the first weekend. So there's no history because there's no reason for history. But this is what it's going to be in order for my client to abide by the court's order. Now, Judge, the court, you've indicated that you, as part of the consideration on custody, you took into consideration the fact that Mr. Gibson was going to be retiring soon and would have more time to spend with Jalen. And the problem with that is he testified that when he does retire, his income is going to, his pension is going to be about $2,700 a month. So $800 is going to eat into about 1/3 of his gross monthly income. I think the one thing that counsel and I can agree on is the numbers for the worksheet, and it would be the 5,500. In the amounts that she indicated were, we're in agreement. We're in agreement on those. My client's income being the 55,2487, and her client's income being the 37,57 per month. My client does carry the medical and dental insurance, and he's willing to continue to. He's not asking for any kind of consideration for that. We just ask that, and I have no problem with them being responsible for being responsible for pro rata shares of whatever's uncovered. But at this point, Judge, it just appears to us that it's almost as if Mr. Gibson is being punished for having sought custody and obtained custody, and he's punished for having made efforts to give his daughter a better life. When the court ruled back in September that he was going to get custody, that of course he was happy about that. But subsequent to that, and looking at the finances, he's troubled because he realizes if he only has $478 child support coming in for the support of the minor child, then child is not benefiting from the child support that's being paid, and the child is losing out because there's money going outside of the household, so he can pursuant to the court's order, so he can allow Miss Spratley to exercise her visitation or parenting time. One of the problems throughout, Judge, has been that Miss Spratley has no skin. She has no skin in the game. The court ruled against her. She went ahead and got her family members and her fiance to get her $6,500 to hire an attorney. Ms. Gates has filed multiple motions, which we're going to have to, we've responded to a few, which we're going to have to respond to, argue. And the fact is that she has not spent one dime. And she's spending everyone else's money. And even though today she testified that she never testified in this case that her fiance was paying all these bills at such time when the transcripts are available, the court will see that that's not what she testified to in previous hearings. She testified that her fiance paid all of her bills as he had been paying all of her bills over the years. So what we're asking, Judge, is for you to take into consideration these additional expenses, the tutoring and the travel. Some tutoring is self-imposed, and if Mr. Gibson has to pay the whole amount or a proportion or a percentage of it, that's fine. If he has to pay the whole thing, he's willing to do that in order to get his child out of the educational hole that she's in, and which Miss Spratley has helped create. And also what wasn't self-imposed though is this $800 per month that he is potentially going to be expending, because there's no way he can drive from Waycross, or he says he lives in Blackshear, to Lithonia at 10 o'clock at night, then go back to Waycross on Saturday, and then come back on Sunday to pick up Jalen, and then go back home on Sunday evening. It doesn't make good sense. So we'd ask the court to take those considerations in effect for the calculation of child support. He'll continue to carry the medical pro rata for the uncovered expenses. Consideration be given for the additional expenses that he's testified to today, and that we'd ask the court to reserve the issue of attorney's fees. Thank you, Judge.
Thank you. So let me start by saying the hearing for today was really limited to one small issue, and that was her income, period. That was it. It was the only information I did not have. It was not to look at travel expenses. It was not to look at the transcripts and all other things that she said. And it was not to look at what the decisions that the court had already pretty much ruled on the record. It was simply to get her income, okay? So that we can plug it into this information, because although we took the temporary facts into the case, we recognize that time definitely could change circumstances related to income, okay? And so as a result, that's the only reason I reopened the evidence for that small, very limited issue, which I anticipated when I put on the calendar today was gonna take me about 15, 20 minutes, literally. That's what I thought. And that was the only reason I was doing it. I feel saddened by Mr. Gibson believing that he's being punished. Mr. Gibson is not being punished. The evidence in this case showed that Ms. Bradley has a disability. She is disabled. And she's indicated that that prevents her from making trips to you all live 5 hours apart. I didn't create that. You all created it. Okay. And it is very difficult for her to meet you. And you were having significant amount of issues with her meeting you. And her position was she was having those issues getting people to meet you or trying to get herself there because she cannot drive. That's just your circumstance. Okay. You indicated to me that it appeared to the court that you were willing and that you understood that there were going to be some challenges to the fact that if you were to retain custody or to gain custody. I thought that you would be understanding in that position and that you would be the better co-parent as a result of it. Your position is that you were about to retire. So in consideration of that, you taking a weekend off because you're going to have 30 other free days, not free days, but you're retired. So you losing a weekend so that the mother could see her child did not seem to be punishment to me. It seemed to make rational sense. Now, if you were working every single day, your weekends are really a big deal because that's the only time you're going to have to spend with your daughter. But if you're retired, you have more time. And consequently, that's the reason why I decided to do that, was because you would have more time, which means that losing one weekend a month was not going to be extremely detrimental when you have all the other days that you're home, spending time with your daughter that Ms. Bradley would not have. So I don't want you to think of it as a punishment, and I'm surprised that you do, because that's what it's not. It's just the circumstances of your relationship. You live 5 hours apart, and somebody has to do the drive. And when you have someone disabled, what do you want me to do? You want to come back here every month when she tells you she can't make the trip because her body is broken down, or she can't make the trip because her legs won't work? You're going to be here every month. And trust me, I know you too. So you would be here every month. So I'm trying to make circumstances, one, so that I don't see you every month. And two, take into consideration the reality of your circumstances, or at least what they were presented to the court. So I like to think outside of the box on various things. I don't know exactly how the weekend is going to work. I do recognize that Fridays are late. So some of the consideration I was having was early to have her there on Saturday morning, perhaps. I'm going to think through it. But the whole idea was that it was just one weekend a month. Literally every other weekend you're going to meet 2.5 hours, and one weekend you're going to do the full trip. But anyway, I digress. The idea is that I have what I need to make the final decision with regard to the child support worksheet, child support amount. I will use the worksheets. I'm thinking all of you already have. And that's kind of where we are with regard to it. The tutoring will be Mr. Gibson's because I'm not going to put that in the worksheets. Okay. And I think that's it. Y'all have a good day. Let me deal with the second case, the legitimation. So here's what concerns me about the legitimation. So initially your position was, as I understand Mr. Allen this morning, that you wanted legitimation, and not only did you want legitimation, but you wanted custody. Okay. And in the custody situation, you wanted child support. When you came to the resolution that you're not going to get custody, you don't want legitimation as a result of you don't want child support. And that's kind of alarming to me. You don't want to pay child support. So as a result, you're going to deny your child birthright privileges, inherited privileges, because you don't want to pay child support. But you were here asking this court to make her pay child support when you wanted to get the child for child custody purposes. And now you want to dismiss the case so you don't pay child support. Is that what I'm hearing?
Your Honor, good afternoon. And I do appreciate the court's time to correct the statement on behalf of my client.
Right.
His position is that he actually pays childcare, Your Honor. He's the one who pays the childcare. He has this child, honestly, my understanding is about 75% of the time at this point. The child is in his home at least every week, if not, well, at least every other week. Currently, they're on, week off, and sometimes more than that. So he's buying clothes, he's buying food, he's buying diapers and taking care of the child. So my conversation, just to be transparent with the court, was that Mr. Allen believes he is providing for his child. I did discuss with him the options of legitimation, but ultimately it's not, I just don't want the court to be under the impression that he doesn't want to support his child. He actually expressed and would want the court to know that he believes he is supporting his child, and he would like to do that just directly with Ms. Groves. And that's how they, negotiated and discussed how they wanted to proceed, Judge.
Who initially did you do your documents yourself, Mr. Allen, or did you always have an attorney?
Which document?
Your documents, your initial legitimation. Did you have an attorney?
No, I did it myself.
I
believe Attorney Stokes filed it.
Right. So in July, you asked the court to have Ms. Groves pay you child support. And today, when you came to a resolution, you no longer want, when you're not going to have custody of the child, now the child support is not an issue. It doesn't look good, is what I'm trying to say. How is it that when you wanted the child in your custody, you wanted child support? But when she wants the child in her custody, you don't think child support is applicable. You wanted me to do child support for her, but not for you. Right? Because that's what you asked for. You asked for her to pay you child support, right? And now that you all agreed otherwise, you don't want to pay her child support. I think Ms. Stokes can tell you as well that even though those things that you're paying, if you're paying childcare, those things go inside the worksheet. So it's not like it's taken from you. You'll get credit for those things inside of the worksheet. I just find I have a hard time comprehending how you don't want to legitimate your child to prevent from paying child support. That's all. That's not my approach, but. Okay, what's your approach? Is that you just ask, miss it?
Yes, I don't want to deal with. I'm sorry, first of all, that I've taken the time out of your day and wasted my attorney's time. But me and Tadra have come to an agreement that we do not want to deal with these problems and that we are willing to work things out for the sake of our child and just to have a better quality of life. And I know it's hard for everyone to comprehend that, but that is what me and Taja have come to a conclusion about. And so what I am expressing is that I don't want to further this battle between me and his mother. And we are both willing to take the responsibility for our son and work out our issues as they come about. But me and Taja are willing to work things out amongst each other like intelligent, mature adults.
Right. All right. Ms. Groves, do you understand what the court was saying to you? Your position is what you want to dismiss the legitimation because, I mean, it's your call. I'm gonna let you call it. Your position is you want me to accept it and not consider it as paternity issue. I will. But to me, it did concern the court, which is the reason why I asked you guys to hold on, because it concerns the court that you file all of these documents, you ask for child support, and then all of a sudden you dismiss the entire legitimation case to prevent from paying child support. All right. So your position is you just want the case dismissed.
Yes, ma'am. I understand his position. I know he was saying that he does pay I know when we first did this, we had a temporary order in place and we did all our expenses. So in the beginning, they were saying that the $210 that he pays per month will be allocated towards his, I guess, child support in a sense. So I'm okay with that. As long as he just pays daycare, I don't really need any child support from him. I mean, I take care of my son just fine.
What I say to you is I'm going to dismiss this case and there won't be anything holding him to pay anything for you. Okay. So I'm going to dismiss it. I just want you to understand that. So
yes,
if he pays, he's just paying because he wishes to pay. You don't have any authority for him to pay it, is what I'm trying to say. Yes, ma'am. And I want you to know, Mr. Allen, just so you'll know, if you file this case again, it's coming right back.
We don't want these problems. I don't want these problems. My son doesn't want these problems. Tyler doesn't want these problems.
It's not the problem. It's just that your child is not legitimated because you want to dismiss the case.
My son will be fine.
Yeah. Okay. Dismissed.
Okay.
Thank you, Judge. Mm-hmm.
Thank you, Judge.
I'll take care. What's going on, General?
So essentially, there was my client had a tenant that held over, and she pursued a dispossessory earlier in the year, and that was since appealed, and he is still occupying the unit and has not paid rent since the beginning of this year. And so we would like to establish, fair market value of the rent and to have him pay that. And,
okay. Let me look. Yes. I'm going to look at my calendar now and see if I can get it back done. Get it back on the calendar within the week. Let me see real quick, see if I can put it somewhere.
We do think that our side would only take about 10 minutes.
I know attorneys, Ms. Fox.
I understand. Thank you.
Well, you don't know us, Judge.
I know I shouldn't judge a book by its cover, huh?
Right. I have a conflict from the 2nd through the 6th, Judge.
2nd through the 6th. All right.
If you reset it, is there any way that we could just go ahead and set the whole thing for trial so we could, resolve the ultimate issue at hand as well, which is possession of the property?
Well, we actually
have a trial calendar in November, I believe. Alina, do we have a trial calendar in November where this one can be placed on?
November 6th through the 8th, but it's lightly stacked.
Lightly stacked or thickly, or huh?
And the 6th is a bad day, as I said, Judge. I'm not going to be.
Okay. What about the 8th?
Well, I mean, but we asked for a jury trial, so that's a jury trial calendar you have on it?
Yeah. How long do you think it'll take you to try it?
This is a one-day trial, Judge.
One day.
All right. Let's put it, tentatively the 7th through the 8th. And then I'm going to see. But if I don't hear the trial that day, I can at least do the temporary on the grant. Okay.
Okay. Thank you, Judge.
So November 7th through the 8th, that's what we're looking at.
Perfect.
Okay, I'll prepare the notice.
All right. Thank you.
Thank you.
Yes, sir.
I'm object to that date. I got conflicts. I'm coming back. Those first 2 weeks of November are real bad for me to be doing a trial.
And why is that? This is from below. You don't usually get but 30 days on those to get ready to go.
Why? You said why is what? That I have a conflict?
No. Why won't you be ready? What's preventing you from being ready?
Well, if I'm just coming back to my office on the 7th and I'm going back into a trial on the 8th, but I mean, whatever they want to do, put on the calendar for the 8th. We'll do it then.
No, I'm gonna put it on the 7th. Because I might have to start it on the 7th just to make sure it's done on the 8th. So I'm not sure. It probably won't be Saturday. It won't be the 7th, the morning of the 7th, but we might have to bring them in bring the jury in 1:30 on that Wednesday calendar. But I can assure you it won't be Tuesday morning, but it might be Tuesday afternoon. And then I'll see to make sure that we can try it on Tuesday.
But don't we have a discovery period in this case?
Not really. It's coming from the appeals court. Generally, if you were to ask for it, like if you ask the court to start discovery over, then we could start it over. But if you don't ask for it, I think it tells me to put it on immediately. Let me look at the case law on it. Khalil, look at the case law on it from when it comes from appeals. But I think it's almost like you said.
I think it's de novo and we start all over, Judge.
I'm pretty sure once it comes to me, I put it on it says the next available trial calendar. So I'll double check it. If I'm wrong, don't mind taking it off and giving you what you want. But if I'm right, which I feel like I am, it's supposed to go on the next available trial calendar when it comes from appeals. So I'll take a look at it. If I'm wrong, we'll take it off and I'll just look at the rent. But if I'm right, got to be ready to go. Okay?
Well, I'm gonna file a motion asking for some discovery, Judge, because I really expect this to be some discovery involved in this case.
Well, we'll see.
The fact that he's asking for a trial this quick, we're not ready for the trial on the 6th.
So like I said, I'm gonna take a look at the statute and I'll let you know what I'm gonna do. But you can file whatever motions you think are necessary, okay?
Will do.
All right, y'all take care.
One dime. And she's spending everyone else's money. And even though today she testified that she never testified in this case that her fiance was paying all these bills at such time when the transcripts are available, the court And the court will see that that's not what she testified to in previous hearings. She testified that her fiance paid all of her bills as he had been paying all of her bills over the years. So what we're asking, Judge, is for you to take into consideration these additional expenses, the tutoring and the travel. Some tutoring is self-imposed, and if Mr. Gibson has to pay the whole amount or a proportion or a percentage of it, that's fine. If he has to pay the whole thing, he's willing to do that in order to get his child out of the educational hole that she's in, and which Miss Bradley has helped create. And also, what wasn't self-imposed though is this $800 per month that he is potentially going to be expending, because there's no way he can drive from Waycross, or he says he lives in Blackshear, to Lithonia at 10 o'clock at night, then go back to Waycross on Saturday, and then come back on Sunday to pick up Jalen, and then go back home on Sunday evening. It doesn't make good sense. So we'd ask the court to take those considerations in effect for the calculation of child support. He'll continue to carry the medical pro rata for the uncovered expenses. Consideration be given for the additional expenses that he's testified to today, and that we'd ask the court to reserve the issue of attorney's fees. Thank you, Judge.
Thank you. So let me start by saying the hearing for today was really limited to one small issue, and that was her income, period. That was it. It was the only information I did not have. It was not to look at travel expenses. It was not to look at the transcripts and all other things that she said. And it was not to look at what the decisions that the court had already pretty much ruled on the record. It was simply to get her income, okay? So that we can plug it into this information, because although we took the temporary facts into the case, we recognize that time definitely could change circumstances related to income, okay? And so as a result, that's the only reason I reopened the evidence for that small, very limited issue, which I anticipated when I put on the calendar today was going to take me about 15, 20 minutes. Literally, that's what I thought. And that was the only reason I was doing it. I feel saddened by Mr. Gibson believing that he's being punished. Mr. Gibson is not being punished. The evidence in this case showed that Ms. Bradley has a disability. She is disabled. And she's indicated that that prevents her from making trips to you all live 5 hours apart. I didn't create that. You all created it. Okay. And it's very difficult for her to meet you. And you were having significant amount of issues with her meeting you. And her position was she was having those issues getting people to meet you or trying to get herself there because she cannot drive. That's just your circumstance. Okay. You indicated to me that, it appeared to the court that you were willing and that you understood that there were going to be some challenges to the fact that if you were to retain custody or to gain custody. I thought that you would be understanding in that position and that you'd be the better co-parent as a result of it. Your position is that you were about to retire. So in consideration of that, you taking a weekend off because you're going to have 30 other free days, not free days, but you're retired. So you losing a weekend so that the mother could see her child did not seem to be punishment to me. It seemed to make rational sense. Now, if you were working every single day, your weekends are really a big deal because that's the only time you're going to have to spend with your daughter. But if you're retired, you have more time. And consequently, that's the reason why I decided to do that, was because you would have more time, which means that losing one weekend a month was not going to be extremely detrimental when you have all the other days that you're home, spending time with your daughter that Miss Bradley would not have. So I don't want you to think of it as a punishment, and I'm surprised that you do, because that's what it's not. It's just the circumstances of your relationship. You live 5 hours apart, and somebody has to do the drive. And when you have someone disabled, what do you want me to do? You want to come back here every month when she tells you she can't make the trip because her body is broken down, or she can't make the trip because her legs won't work? You're going to be here every month. And trust me, I know you too. So you would be here every month. So I'm trying to make circumstances, one, so that I don't see you every month, and two, take into consideration the reality of your circumstances, or at least what they were presented to the court. So I like to think outside of the box on various things. I don't know exactly how the weekend is going to work. I do recognize that Fridays are late. So some of the consideration I was having was early to have her there on Saturday morning, perhaps. I'm going to think through it. But the whole idea was that it was just one weekend a month. Literally every other weekend you're going to meet 2.5 hours, and one weekend you're going to do the full trip. But anyway, I digress. The idea is that I have what I need to make the final decision with regard to the child support worksheet, child support amount. I will use the worksheets I'm thinking all of you already have. And that's kind of where we are with regard to it. The tutoring will be Mr. Gibson's because I'm not going to put that in the worksheets. Okay. And I think that's it. Y'all have a good day.
Thank you. You too.
Let me deal with the second case, the legitimation. So here's what concerns me about the legitimation. So initially, your position was, as I understand, Mr. Allen this morning, that you wanted legitimation, and not only did you want legitimation, but you wanted custody. Okay, and in the custody situation, you wanted child support. When you came to the resolution that you're not going to get custody, you don't want legitimation as a result of you don't want child support, and it's kind of alarming to me. You don't want to pay child support. So as a result, you're going to deny your child birthright privileges, inherited privileges, because you don't want to pay child support. But you were here asking this court to make her pay child support when you wanted to get the child for child custody purposes. And now you want to dismiss the case so you don't pay child support. Is that what I'm hearing?
Your Honor, good afternoon. And I do appreciate the court's time to correct the statement on behalf of my client.
Right.
His position is that he actually pays childcare, Your Honor. He's the one who pays the childcare. He has this child, honestly, my understanding is about 75% of the time at this point. The child is in his home at least every week, if not, well, at least every other week. Currently, they're on, week off, and sometimes more than that. So he's buying clothes, he's buying food, he's buying diapers and taking care of the child. So my conversation, just to be transparent with the court, was that Mr. Allen believes he is providing for his child. I did discuss with him the options of legitimation, but ultimately it's not, I just don't want the court to be under the impression that he doesn't want to support his child. He actually expressed and would want the court to know that he believes he is supporting his child, and he would like to do that just directly with Ms. Groves. And that's how they, negotiated and discussed how they wanted to proceed, Judge.
Who initially did you do your documents yourself, Mr. Allen, or did you always have an attorney?
Which document?
Your documents, your initial legitimation. Did you have an attorney?
No, I did it myself. I believe Attorney Stokes filed it.
Right. So in July, you asked the court to have Ms. Groves pay you child support. And today, when you came to a resolution, you no longer want, when you're not going to have custody of the child, now the child support is not an issue. It doesn't look good, is what I'm trying to say. How is it that when you wanted the child in your custody, you wanted child support? But when she wants the child in her custody, you don't think child support is applicable. You wanted me to do child support for her, but not for you. Right? Because that's what you asked for. You asked for her to pay you child support, right? And now that you all agreed otherwise, you don't want to pay her child support.
Okay,
because I think Ms. Stokes can tell you as well that even though those things that you're paying, if you're paying childcare, those things go inside the worksheet. So it's not like it's taking from you. You'll get credit for those things inside of the worksheet. I just have a hard time comprehending how you don't want to legitimate your child to prevent from paying child support. That's all. That's
not my approach. But
okay, what's your approach? Because you just asked, miss it.
Yes, I don't want to deal with. I'm sorry, first of all, that I've taken the time out of your day and wasted my attorney's time. But me and Tadra have come to an agreement that we do not want to deal with these problems, and that we are willing to work things out for the sake of our child and just to have a better quality of life. And I know it's hard for everyone to comprehend that, but that is what me and Tadra have come to a conclusion about. And so what I am expressing is that I don't want to further this battle between me and his mother, and we are both willing to take the responsibility for our son and work out our issues as they come about. But me and Tadra are willing to work things out amongst each other like intelligent, mature adults.
Right. All right, Ms. Groves, do you understand what the court was saying to you? Your position is what you want to dismiss the legitimation because, I mean, it's your call. I'm gonna let you call it. Your position is you want me to accept it and not consider it as a paternity issue. I will. But to me, it did concern the court, which is the reason why I asked you guys to hold on, because it concerns the court that you file all of these documents, you ask for child support, and then all of a sudden you dismiss the entire legitimation case to prevent from paying child support. All right, so your position is you just want the case dismissed.
Yes, ma'am. I understand his position. I know he was saying that he does pay I know when we first did this, we had a temporary order in place and we did all our expenses. So in the beginning they were saying that the $210 that he pays per month will be allocated towards his, I guess, child support in a sense. So I'm okay with that. As long as he just pays daycare, I don't really need any child support from him. I mean, I take care of my son just fine.
What I'm saying to you is I'm going to dismiss this case and there won't be anything holding him to pay anything for you. Okay, so I'm going to dismiss it. I just want you to understand that. So
yes,
if he pays, he's just paying because he wishes to pay. You don't have any authority for him to pay it, is what I'm trying to say.
Yes, ma'am.
And I want you to know, Mr. Allen, just so you'll know, if you file this case again, it's coming right back.
We don't want these problems. I don't want these problems. My son doesn't want these problems. Tyler doesn't want these problems.
It's not the problem. It's just that your child is not legitimated because you want to dismiss the case.
My son will be fine.
Yeah. Okay. Dismissed.
Okay.
Thank you, Judge.
Mm-hmm.
Thank you, Judge.
I'll take care. All right. Got one case left. And unfortunately, it's like I'm out of time. Can you tell me generally what the issue was in this matter? Let's see. It was Carlotta, Jackson, Schaefer. So Mr. Huffman and Mr. Emerson. Is Mr. Huffman on?
I'm here on behalf of Paul Huffman representing Carlotta Jackson. I'm Jordan Fox.
Okay, Ms. Fox, tell me what's going on, generally.
So essentially, there was my client had a tenant that held over and she pursued a dispossessory earlier in the year, and that was since appealed, and he is still occupying the unit and has not paid rent since the beginning of this year. And so we would like to establish, fair market value of the rent and to have him pay that. And,
okay. Let me look. I'm going to look at my calendar now and see if I can get it back done. Get it back on the calendar within the week. Let me see real quick, see if I can put it somewhere.
We do think that our side would only take about 10 minutes.
I know attorneys, Ms. Fox.
I understand. Thank you.
You don't know us, Judge.
I know I should judge a book by its cover, huh?
All right. I have a conflict from the 2nd through the 6th, Judge.
2nd through the 6th. All right.
If you reset it, is there any way that we could just go ahead and set the whole thing for trial so we could, resolve the ultimate issue at hand as well, which is possession of the property?
No, we actually jury trial.
Have a trial calendar in November, I believe. Alina, do we have a trial calendar in November where this one can be placed on?
November 6th through the 8th, but it's lightly stacked.
Lightly stacked or thickly stacked? Huh?
And the 6th is a bad day, as I said, Judge. I'm not going to be.
Okay. What about the 8th?
But we asked for a jury trial, so that's a jury trial calendar you have on it?
Yeah. How long do you think it'll take you to try it?
This is a one-day trial, Judge.
1 day.
All right. Let's put it. Let's tentatively the 7th through the 8th, and then I'm going to see. But if I don't hear the trial that day, I can at least do the temporary on the rent. Okay.
Okay. Thank you, Judge.
So November 7th through the 8th. That's what we're looking at.
Okay, I'll prepare the notice.
All right. Thank you.
Thank you.
Yes, sir.
I'm object to that date. I got conflicts. I'm coming back. Those first 2 weeks of November are real bad for me to be doing a trial.
And why is that? This is from below. You don't usually get but 30 days on those to get ready to go.
Why? You said why is what? That I have a conflict?
No. Why won't you be ready? What's preventing you from being ready?
Well, if I'm just coming back to my office on the 7th and I'm going back into a trial on the 8th, but whatever they want to do, put on the calendar for the 8th. We'll do it then.
No, I'm gonna put it on the 7th. Because I might have to start it on the 7th just to make sure it's done on the 8th. So I'm not sure. It probably won't be Saturday. It won't be the 7th, the morning of the 7th, but we might have to bring them in bring the jury in 1:30 on that Tuesday calendar. But I can assure you it won't be Tuesday morning, but it might be Tuesday afternoon. And then I'll see to make sure that we can try it on Tuesday.
But don't we have a discovery period in this case?
Not really. It's coming from the appeals court. Generally, if you were to ask for it, like if you ask the court to start discovery over, then we could start it over. But if you don't ask for it, I think it tells me to put it on immediately. Let me look at the case law on it. Khalil, look at the case law on it from when it comes from appeals. But I think it's almost like you said.
I think it's de novo and we start all over, Judge.
I'm pretty sure once it comes to me, I put it on it says the next available trial calendar. So I'll double check it. If I'm wrong, don't mind taking it off and giving you what you want. But if I'm right, which I feel like I am, it's supposed to go on the next available trial calendar when it comes from appeals. So I'll take a look at it. If I'm wrong, we'll take it off and I'll just look at the rent. But if I'm right, gotta be ready to go. Okay?
Well, I'm gonna file a motion asking for some discovery, Judge, because I really expect there to be some discovery involved in this case.
Well, we'll see.
That's the fact that he's asking for a trial this quick. I mean, we're not ready for the trial on the 6th.
So like I said, I'm gonna take a look at the statute and I'll let you know what I'm gonna do. But you can file whatever motions you think are necessary, okay?
Will do.
All right, y'all take care.